Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about murder and search and seizure. Cases that should have gone to the Supreme Court of Canada, but didn't. Michael Acumen was charged in connection with a shooting in downtown Winnipeg. Essentially, the theory of the case at trial was that Mr. Acumen had run into a nearby residence, hid out there, and when he was discovered by police, he claimed falsely that he stayed there and enjoyed an expectation of privacy in the residence. Ultimately, a search was conducted of the residence, and a firearm was located. The court determined that Mr. Acumen did not have standing to challenge the search of the residence because he claimed that he lived there and that that was false, even though the prosecution was relying on his presence in the residence and the gun being in the residence to make a connection to him being the alleged shooter. This raised an important issue of whether he had the right to say that his privacy rights were violated in the way that the search was conducted in the residence that may or may not have been his. In order to make a claim that a search violated your rights, first you have to prove in court that you have standing to challenge that search, in that you have a privacy interest in that place. A recent Supreme Court of Canada ruling had determined that people have an interest in their digital communications, and if the theory of the case that the Crown was relying on was that a person had authored a text message, they had a privacy interest in that text message itself. The issue arose in Mr. Acumen's case about whether, in relying on the Crown's theory of the case that he had occupied that residence and that he had an interest in that residence, that he had control over that residence, that he had ultimately developed standing, or whether the Supreme Court of Canada's decision was only limited to searches of digital evidence. The court in Mr. Acumen's case ultimately found that it wasn't necessary to grant him standing because the Supreme Court of Canada's decision had applicability only in the case of digital searches, not hard evidence searches. And this raised an important and significant issue in our justice system. What is more private than your actual residence? The old saying goes, a man's home or a woman's home is their castle. And so to say that a person who is theorized to be living or staying at a particular location doesn't have a privacy interest just because their interest there is in something physical as opposed to something digital raises huge questions about the degrees and nature of privacy that we have and whether we have more privacy rights in our digital communications than we do in our physical locations. That's a significant type of issue that the Supreme Court of Canada absolutely should have grappled with, if only to clarify whether their ruling only had applicability in the digital context or whether it applied to all searches and all seizures. And unfortunately now there's this lack of clarity in the law that's unaddressed by these cases. The Supreme Court of Canada had the opportunity to provide the necessary clarity because the standard that was applied in Mr. Acumen's case has not been applied in many other cases. Suggesting that the judge got it wrong there, and that perhaps there was a wrongful search or a wrongful conviction for a very serious offense. These are the types of things that the Supreme Court of Canada should be engaging with, and unfortunately they missed a real opportunity here to provide some necessary clarity to guide judges in dealing with these issues at trial in many cases. Hopefully this issue comes up again, and that the Supreme Court of Canada takes the opportunity to clarify that indeed the standing decision that they rendered on digital evidence applies equally to physical evidence. Otherwise, we're in for a legal quagmire. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.